Hello, Leadership Premier Class of 2020. I'm John May, partner with the law firm of Rosenberg, Martin, and Greenberg. I'm also the immediate past chair of Leadership Howard County and a member of the class of 2002. I will be your guide for this presentation entitled Top 10 Things Every Nonprofit Director Should Know About Fiduciary Duties, Board Responsibilities, and Good Governance. So, I have some good news and some bad news about this presentation. The good news is that I've tried to think of ways to make it both informative and fun. The bad news is that given the subject matter, you might find it more informative than fun. In any event, before we get started on our top 10 list, I thought I would tell you a few stories about the types of things that can happen when boards and their directors don't fully understand or properly carry out their duties and responsibilities. The names have been left out to protect the tragically embarrassed. Our first story is called, But What About the Children? In April of 2015, the New York Attorney General issued a press release about actions taken against trustees of a charitable fund. For many years, the purpose of the fund was to make grants to support underprivileged children. But several years earlier, the fund's purpose was changed to that of supporting the development of a children's choir. In addition, the fund changed its investment portfolio strategy and proceeded to lose about 75% of the portfolio's value. So the Attorney General's office asked, what about the children? And where were the trustees? Well, the Attorney General's office found that the trustees had failed in their fiduciary duties in several ways. They allowed insider and ill-advised transactions to the benefit of the fund's leader. He was overcompensated and got a above-market housing allowance. They failed to exercise reasonable care in supervising and overseeing the fund's activities, such as allowing risky investments and permitting some trustees to personally benefit from transactions. The Attorney General cited the fact that the trustees rarely met and even failed basic principles of sound governance, such as lack of meeting minutes, failure to review budgets, and generally a lack of resolutions relating to governance matters. The verdict? Over $1 million paid by trustees to settle the case, and one trustee was, quote-unquote, banned for life from the service as a fiduciary of a nonprofit formed or operating in New York. Our next story is called When Recreation is Not All Fun and Games. In a recent Maryland court case, two independent contractors sued a local association which oversaw recreation and parks programs for kids. They claimed that the association had failed to pay amounts claimed due under a contract. Several individuals serving in various leadership capacities were also named as defendants. The court found that the association did in fact owe the money to the claimants on the contracts as they claimed. However, to the surprise of the individual defendants, they found that they too were subject to personal liability. Why and how could this be? Well, it turns out the association was unincorporated and thus had no corporate liability shield. This was the case even though the association operated on a not-for-profit basis. Will this be fixed? We'll have to wait for a legislative change. And our last story is called No Standing Ovation for This Board. The Pennsylvania Attorney General is not happy about the recent goings-on at some nonprofits and believes that their boards may have breached their fiduciary duties. In one matter, it's alleged that among other breakdowns, the board failed to make sure insurance was maintained on an historic theater, which was then destroyed by fire. In another situation, directors are alleged to have mismanaged the finances because they approved a multi-million-dollar construction loan but had no viable debt repayment plan and the project went into foreclosure. The Pennsylvania Attorney General is considering bringing actions to seek removal of the directors and to collect substantial payments. Yes, these stories are a bit scary, but hopefully they'll serve as a warning sign and will encourage everyone to take seriously the matters we're about to hear about. So with that covered, let's move on to our top 10 list of things every nonprofit organization director should know. Number 10, fiduciary duties of directors serving on nonprofit boards 1. The general duties. Act in good faith. This is in contrast to acting to further your own interest or those of a third party. What you must do is act in a manner that's reasonably believed to be in the organization's best interest. The specific legal fiduciary duties are as follows: the duty of care, the duty of loyalty, and the duty of obedience. We will take each of these in turn. Number 9, the duty of care. This is about good faith, engagement, and reasonable decision making. The main tenet of the duty of care fiduciary duty is acting as an ordinarily prudent person would. This is called the prudent person standard. What would such a person do under similar circumstances? So, how do you comply with this standard? You don't have to be perfect, but you need to act in a reasonable manner. Number 8. How to fulfill your duty of care as a nonprofit organization director. Here are some practical considerations. Do your homework. Ask questions and get the information you need to make decisions. You need to be a participant in meetings. You need to make informed and thoughtful decisions. Proper and reasonable delegation of duties is permitted. Reasonable reliance on information that others provide. Note the word reasonable. Unreasonable reliance on something that clearly has suspect information in it cannot be relied upon. Give the necessary time. Consider short, mid, and long-term impacts of decisions. Set sound policies that can and will be followed. Be creative and open-minded. Expect and require periodic compliance reviews from management. And be aware of budget matters. All in all, have the organization first mindset. Number 7, the duty of loyalty. This is comprised of two basic components: undivided allegiance and confidentiality. Undivided allegiance is allegiance to the organization itself. You have to make sure that any corporate opportunity stays with the organization and doesn't go with you or your family or friends. And you must always act in the organization's best interest. With regard to confidentiality, we're talking about the confidentiality of the organization's information. So, what happens in the boardroom stays in the boardroom until that information is purposely disclosed by the board or otherwise made public. A board should speak with one voice through a designee. This helps avoid inadvertent disclosures and message confusion. Number 6, the duty of obedience. This also has two parts: adherence to the organization's mission and adherence to law. With regard to the organization's mission, how do you do this? 1. Know the mission. 2. Be familiar with the organization's activities and operations. Next, focus on strategy. And, as said before, have a mission-first mindset. With regard to law, adherence to the laws that apply to the organization are paramount. In order to do that, you must have some familiarity with the legal and regulatory landscape in which the organization operates. Number 5, be familiar with your organization's legal and regulatory landscape. What do you need to know? Be familiar with the state laws that may apply. For example, corporate governance. How is your organization regulated under state law and regulation? Next, as with most nonprofit entities, they depend on fundraising. Charitable solicitation, registration, and fundraising rules exist and should be checked to make sure you are in compliance. Next, charitable asset protection and the role of the Attorney General. It's paramount to understand that the Attorney General's Office of the state has authority to make sure that charitable assets within charitable organizations are used for the purposes they were intended for. Next, licensing and regulations of operations and activities. Obviously, different activities are subject to different sets of laws and regulations. Someone needs to make sure that they know what they are. And last, because it's so important for nonprofits, tax and tax-exempt status laws. These exist at both the federal and state level. So under the federal law section, knowing and understanding what federal tax statutes and regulations apply is important. From a taxation point of view, most organizations you will deal with are what we call 501c3 charities. So 501c3, as part of the tax code, has a lot of rules and regulations that require constant compliance in order to maintain that status. Another compliance matter involves something called the Federal Sarbanes-Oxley Act, which has been in force for about 20 years. Most provisions of this act apply to public companies. However, there are two particular parts of this rule that apply to everyone, including nonprofits. And those are, one, protections for whistleblowers, and two, document retention obligations. In other words, you can't just go around destroying documents once you hear there's a problem. Number 4, the Internal Revenue Service Form 990, Fun with Taxes. What does a director need to know? First, if an organization is 501c3, as the organizations you are or will serve on most likely are, there must be an annual filing with the Internal Revenue Service on Form 990. This is extremely important because of a rule called automatic revocation. Failure to file the Form 990 on a timely basis can ultimately result in the organization losing its hard-fought and won 501c3 status. The next thing that's important to know is that this is a public document. There is required disclosure of it to those who ask. And guess what? Everyone is looking. Funders, regulators, watchdogs, volunteers, reporters, etc. This form tells the story of the organization's financial, operational, and legal information. It also covers governance and policy questions, things that the board should be reviewing. The form covers compensation and who gets paid and discloses how much. It also talks about related party transactions and associated entity transactions. They're all disclosed on this form. Any lobbying that the organization does is also disclosed. And finally, something we call unrelated business income. This is income from activities that is not consistent with a nonprofit mission. The good news is that there's a part of the form called Schedule O. Schedule O is an opportunity to tell your story, disclosing the bad news, but also telling all the good things that your organization does. So what is the board's responsibility with regard to the Form 990? Well, it's pretty simple. The board has to have been provided a copy before it is filed. Most boards also get the opportunity to ask questions, but there is not a direct requirement that boards approve the form. You should also check the organization's charter document. That's the document filed with the State Department of Assessments and Taxation. It should include a provision which states that the limitation of liability exists for any director or officer of the organization who does their job within the bounds that I just spoke about. In addition, there are multiple what we call volunteer protection acts at both the federal and state level. These acts protect volunteers who put their time into nonprofit organizations as so long as they do not commit acts of intentional misconduct or enter into transactions with the organization for personal financial gain, what we call the bad acts. The next item to talk about is indemnification. Indemnification is also an item that you should check the organization's charter and bylaws for. Again, if an organization provides for this in its corporate documents, then to the extent a director is brought into an action and has to be defended, the organization is supposed to indemnify that director for those costs. But as we talked about with liability limitations, bad acts are not covered. D&O insurance. D&O insurance is a very important item for anybody looking to serve on a nonprofit board to find out about. There are state law thresholds where if an organization has D&O insurance within those thresholds, then the director gets coverage and limitations on liability for any act that's covered under that policy. So why do we need these policies? The main reason to have the policy is to cover the cost of defending an action should a director or officer be named. That's what's important. So always ask whether a D&O policy is in place and check it. Look to see if there are exclusions or if you're satisfied with it. So what are the personal liability risks? Well, certain taxes actually pass through to people who are in charge of an organization. Most of these are at the state level, but there are federal ones as well. The most obvious example is if there are payroll taxes that are withheld from employees' paychecks, but not paid over to the government. That is a risk. Also, charitable solicitation violations. I spoke about this under the Know the Legal Landscape, and these provisions come with the possibility of personal liability if they are not followed. The last thing that you have to worry about is if you don't have insurance to cover defense costs. So that's why I say make sure you check out the D&O policy. Number 2, Protection of Charitable Assets Act. Well, this is a relatively recent addition to the Maryland statutory scheme. As the title implies, it relates to charitable assets that are given or received for a charitable purpose. The main purpose of the law is to provide an avenue for the Attorney General to be able to investigate and take actions if it suspects or is told about a misapplication, diversion, or waste of a charitable asset within a charitable organization. So the Attorney General has investigatory powers. That means they have the ability to subpoena and obtain documents, talk to witnesses, and so forth to ferret out whether there has been a breach of fiduciary duty in the governance or management of an organization that holds charitable assets. If the AG investigates and finds there's a problem, it also has enforcement powers. Those enforcement powers are to prevent, remedy, or settle violations, and they can include the following types of items: restraining orders against people or entities in continuing to do certain activities that the AG has determined are problematic; restitution, which is basically finding that there is a responsible party and requiring the repayment of funds; and even transferring the assets of a charitable organization who is found to have not followed its duties and taking those assets and putting them into a different charitable organization. And last, number 1 on our list, before you say yes, or even if you already have, here are some things to do. 1, review. Review the charter, the bylaws, and the policies of the organization for which you serve or want to serve. Review the Form 990 and the financial statements. Understand what they say in terms of what the organization does and how it operates. Check out the insurance and do things like check Google and review the organization's website. Consider interviewing leadership of the organization, such as other board members, the CEO or executive director, or perhaps clients or volunteers or even donors. More information is always good. Get familiar with the organization's legal landscape and understand if you know how it operates. And lastly, always ask yourself the ultimate question. Do you have the adequate time and resource to commit to this organization to be an effective participant as a member of its board? Thank you for listening to the presentation. Again, my name is John May. I appreciate the opportunity to speak with you. And if you have any questions, my contact information is below. Thanks and good luck with the rest of your session.